and I'm happy to, at Altitude Accelerator, I'm Hessie Jones, by the way, and I'm happy to host Joanna Ma from Bereskin Parr, who will actually talk about government funding. There's a lot of opportunities right now in the market for this, and Joanna wanted to, she offered to be able to host a hands-on workshop to give you more visibility and direction into what the opportunities are out there. So without further ado, I'm going to pass it to Joanna.
Thanks, Hessie. So everyone online can hear me as well. So, okay.
Yep.
Thanks for Tuda. So thank you so much for coming out and attending online. We have in person some handouts in the back, which everyone has. And if you email me at the end, I'm happy to send you a copy of the handout as well. We're going to walk through it at the end of the presentation is to make it more of an interactive workshop at the end where we kind of, I'll walk you through the materials in front of you to give you guidance as to which of these government programs you might qualify for and what kind of funding it could be applied towards and what kind of services it would cover. So we're going to walk through the different types of programs today, and then at the end, talk about how it may apply to you and your business. So feel free to ask questions throughout as well, too, just because I think it's good to have that interaction, engagement, and then Rituja will let me know if any questions come. So just briefly about myself and the firm, I'm from Bereskin Parr, which is an intellectual property law firm. So we practice only intellectual property law. So that's patents, trademarks, copyright, anything on the fringe of IP we can assist with. So privacy policy, data agreements, IP clauses within your employment agreement, service agreement, NDAs we can assist with. So anything on the fringe of IP. We have offices in Toronto, Mississauga, Montreal, and Waterloo. I'm based out of our Kitchener-Waterloo office. And a partner there. My background is in electrical engineering. So one of the biggest difference between our firm and a lot of other firms you may encounter is that we do have quite a diverse number of professionals, different technical. So we have quite a large group of electrical and computer technology professionals specializing in biomedical engineering, mechanical engineering, as well, and the life science department, people with all sorts of background in chemistry, biology, and PhDs and masters. So one of the things that I think it's really important when you're trying to figure out how to develop your IP strategy is to make sure that you're paired with the right professionals, with the right technical degree, such that at least they can talk your language. Okay, that's good. So that's just a brief little bit about ourselves. We're also sponsored. We've been sponsored by the Altitude Accelerator for many years. And so today, what we're going to talk about.
Is it not working again?
Oh no, it works. Maybe I just need to press really hard. So today, what we're going to talk about is a variety of government funding that's available for covering IP costs. And so we're going to talk about the different types of IP costs it can cover. Maybe it's just, I'll just keep moving it a little bit. And so IP Assist, for example, you may have heard of. It's under the NRC, so National Research Council. So it's a federal program. Elevate IP just recently launched in the past couple of weeks. It's also a federal program. IP Ontario is unique to Ontario. It's a provincial program. And I emphasize these just because it depends whether you qualify may depend on where you're incorporated, or if you have offices in different provinces, that may lead to different ways you can approach these grants. And some other lesser known programs that may be of benefit of future down the road, so just to keep in mind. So feel free again to ask any questions throughout.
Well, if you don't mind going back and then going in the details, if you're a solopreneur, okay, and your company is registered here, what are the different?
Yeah, and then, so that's going to be the entire next 10 minutes.
Okay.
So the IRAP IP Assist program, National Research Council. And it's the requirements or the eligibility of companies to qualify is listed here. But the key takeaways for all these programs really is that if you are under 500 employees, full-time employees, and you have you're developing technology that will grow and grow commercially and as well as employment within Canada in one way or fashion, you can likely qualify for some of these programs. So the key point is under 500 employees with a commercialization plan of growing your technology and within Canada at least. So once you are looking into IP Assist, there are actually two different routes to approach it. And I'll go through those two different routes. But what you first need to do in order to qualify for IP Assist funding is to get in touch with IRAP and to become what's called an IRAP portfolio client. So this is the link. So if you just Google NRC IP Assist, you'll get to a government page where you can call 1-800 or 1877 hotline, and then you'll be assigned an ITA, an Industrial Technology Advisor. And that's really important for you to get access to the program IP Assist, as well as a lot of different types of government funding that you may be eligible for. So key is to go on this website, call this 1877 number, and be assigned an ITA. Some things to think about when you have an ITA assigned is that it's very difficult to move away from that ITA. Not that you have to, but I found from what my clients have talked about is that some ITAs, if their technology background is very well aligned with you, they understand the different programs that may make life easier for you, and they're very responsive. So some clients have learned that they can shop around for ITAs. But I would say don't feel like you're obligated to go with the first ITA that's assigned to you, or just like talk and engage with a couple and just see which fits with your working situation. So IP Assist program is separated into 3 levels, and this is going to be similar for Elevate IP as well in some ways. The idea of all these federal government programs is that they want to grow awareness and educate what IP is. And so always with these programs, we start off with level 1, awareness. So what's under the IP Assist program, one route is that once you engage with an ITA, they enroll you into the IP Assist program, and then you're assigned a patent professional. So service provider. Bereskin Parr is listed as a service provider, and so you can actually ask specifically for us to be your service provider. You're not obligated to go with any of the ones that they offer or recommend to you. And then the first level is awareness. And so the service provider is given $1,000. And typically for me, when I engage with new clients, is we have an introductory call so that we understand what your business is about, what your needs may be. And then we do a follow-up, about an hour and a half and 2-hour presentation to you, advising on the different types of IP and how it may apply to you. I usually do that through case studies. And then if your company's a little bit more advanced, then we might dive deeper into certain questions. If you're more focused on trademark branding, you want to talk more about trademark branding as it applies to your company, then we engage with a trademark professional, then they have an in-depth conversation with you. And so we work based on your IP needs, your company's needs, but that's level 1. So once you're done level 1, you go back to your ITA and say, hey, we're done. We want to proceed with an IP strategy. And so one route of IP Assist program is that you can enter the level 2 IP strategy development program once you pay a $500 admin fee. One of the biggest benefit of IP Assist, this direction of IP Assist, is that you don't have to pay anything else beyond that $500 admin fee. And that $500 admin fee is to an organization called IPON. So IPON is our administrative board, and they administer this entire program. So once your ITA approves your eligibility to enter level 2, you pay the $500 admin fee, you're qualified for $18,000 of funding. And one of the biggest benefits of this path for a lot of my clients is that you don't have to pay anything more. We work with you to see how best to utilize that $18,000. And I'm going to go through the example plans that you have in front of you as to how we feel like you can maximize that amount of $18,000. the listed item there, like level 2 can range from $18,000 to $25,000. The anything more than $18,000 is another type of IP assist. And I'll go through that in a little bit more detail at the end, but that other type, it's more of the traditional NRC path. If you've ever done NRC proposals, traditionally you have to go through a proposal and their ITA approves how much funding you might be eligible for. The biggest difference is that you do get more money potentially. I've done clients $27,000 of funding, but you need to pay 30% of that. Another part of that, and might be more attractive to clients that are more advanced in terms of their company size or IP portfolio, because it can actually go towards, some of that money can go towards your salary, employee salary for developing and helping with the IP strategy. So that's another route of IP assist. So I'm going to go into detail about that, but that's the range of costs available. And so depending on what happens in level 2, IP strategy development, then you could potentially enter into level 3. Level 3 is only through the NRC approach. So that means you have to go through a proposal with your ITA, explain your needs and what you want to do beyond the level 2 IP strategy development. One big takeaway from all this is that IP Assist does not cover any drafting or filing costs related to your patent or trademark. And so all of this can be used towards patent mining session, trademark branding mining session, patentability searches, landscape searches, trademark clearance searches. A lot of the development or moving towards what you want to potentially implement down the road can be done. I'll list out other items as well that's interesting, but another big thing to consider is the agreement work as well too. So developing an NDA or like IP policy internally, employment agreements, the IP clauses within there. So all of that can be covered IP Assist, but just none of the drafting and filing costs, none of the government fees can be covered under IP Assist. So level 2, eligible services, and these are the typical ones that we would recommend for earlier clients or even more sophisticated clients if they have other technologies down the road that they're considering. And so really develop the idea of level 2 IP Assist is to develop an IP strategy. So one of the things that is maybe more appealing for a later, more advanced client is if they have a couple of IP portfolios or patent portfolios already, and they want to see what within their current product line they're doing, they can use their existing IP or patent portfolio to cover. And so what we could do with you is to analyze your product and understand what your patents cover, and then develop other patent applications or develop patent claims with the priority date of these patent portfolios to cover those product lines. So that's what we call gap analysis. It could be also a gap analysis based on landscape searches. We find prior art that's really relevant to potentially your products, and then we review that and see how best to navigate patents related to your product in view of these prior art that we have located. And also competitive analysis. If you know of certain entities that are really busy in the space, then we can focus a search on those competitors and see what kind of patent filings they have done. But again, none of the legal fees related to drafting, prosecuting, so during the examination route of patent application, trademark applications can be covered under IP Assist, and none of the legal opinions as well as the maintenance fees can be covered under IP Assist. So IP Assist level 3. So level 3, imagine it as like the next step to level 2 of if you want to do deeper dives into searches, for example, or further prior art. If we found a couple of prior art in level 2, and there's actually more interesting prior art we found beyond that, and we're at the end of the budget available under level 2, then we can do a proposal under level 3 and continue that process. More sophisticated competitive analysis or branding strategies beyond what you're doing, and potentially IP auditing as well too, and that plays into your existing IP portfolio, what you have so far, developing strategies in the future as to how you want to protect your future products, where you're going potentially, filing strategies as well too. So a more in-depth advanced level 2. That's what level 3 typically is about. But again, none of the drafting and prosecution costs related to IP can be covered under IP Assist. So that's really about IP Assist. It's actually a really great program for clients to early on to start developing an IP strategy. And reason why is that, as I mentioned before, it's fairly easy to get in once you have an ITA assigned, and you just need to show that, you know, incorporated, you have a plan to commercialize and grow your business and grow that technology, and then you would qualify for the IP Assist $18,000 after a $500 admin fee. And I think most people, if they have engaged with government funding grants, is that the paperwork, the administrative part, it's quite burdensome. So one of the biggest appeal of the IP Assist, the path under EPIC, is that once you pay that admin fee, you have that $18,000 available to you without any more admin paperwork. It's just documentation at the end to show like we're completed the process. So that's one really big appeal. And some, depending on how fast your ITA responds, I have clients going through the application process and being given approved for this program within less than a week or 2 weeks. So it's a really great starting point for a lot of companies, and I would suggest and emphasize that IP Assist is always a good start, but to always complement it with something else as well too. And so that's another thing to remind yourself and remember. None of these programs can go towards the same task. And so we work with our clients to make sure that we maximize the use of your funding as much as possible, but we never overlap, because that's a faux pas completely. So going into the next federal government funding, Elevate IP, it launched officially in Ontario, November 23rd. What's really exciting about Elevate IP is that it covers the government filing fee, it covers the drafting fee. And so if you think about it, if you have IP Assist funding, you can do all the searching, all the strategy work, all the thinking of like filing strategy, all the legal parts of the legal work at least. And then if you qualify for Elevate IP, then that would be the next stage in you being able to implement and execute the IP strategy you've developed. So again, Elevate IP, it's federal. So it's being administered by a series of different incubators. So in Ontario, is being administered by Invest Ottawa as well as Communitech. So if you're more east side of Ontario, then you would go to Invest Ottawa, but otherwise I think most of us would be within the Communitech region. You would go to that link and just go through an application process. It's open right now. It will close, I think, again soon, but they do rounds of application and they review it and see whether you qualify. But again, it's 500 or fewer employees. Otherwise, you would not qualify. And depending on jurisdictions, Communitech has, from what we've heard, is that you need at least 2 full-time employees. But even then, I wouldn't stop from applying. I would just apply and see. The rules of this program keeps evolving because it just launched. And so it's a federal program again, but it's being administered by different provinces. So the East Coast is being administered by Springboard. It actually launched very early before the summer, and it gave away all its money before, I think, the fall. But they also have a different criteria. And so that's why I emphasize, like, if you have offices and potentially incorporate other provinces, it may be more beneficial in other programs to apply. And so that's something we can talk about as well too. BC also recently launched North Forge. It's an incubator in Manitoba who's in charge of Manitoba and Saskatchewan funding as well too. And Calgary does Alberta funding. And so the idea of Elevate IP is, again, to emphasize the need for IP to grow awareness of IP. So they will have a level 1 piece. It's not fully established yet in most of the provinces. But the biggest, like the most exciting part about Elevate IP is, on top of developing an IP strategy, it will help you implement an IP strategy. And I'll go into depth about that. So yeah, so level 1 awareness, it will be implemented soon. In Ontario, it hasn't fully implemented. And the development of IP strategy and implementation. The really exciting part is that for each company, the lifetime of that company, you will qualify once you are eligible or accepted into an Elevate IP program up to $100,000 of funding. The tier 2 funding, it's up to $25,000, and it's completely covered by Elevate IP. The remaining portion of that $100,000, so about $75,000, you would have to pay a portion of that. The range in terms of how much you have to co-pay could range from 10 to 30%. It's changing right now. It depends on, again, jurisdiction and also at which stage you would qualify for the program. But it's pretty amazing. It's taxes on top of that as well too. So this is pure services and government fees. So under tier 2, it's again IP strategy. To qualify for the Elevate IP funding for filing for applications, you do need to do a clearance search in one way or another. So if you haven't gone through IP Assist, then they would require you to go under tier 2 and do a search for that. It's the challenge of that is that if you have a deadline, so if you've gone through the patent process, you understand that the best practice is to file for a patent application before you disclose publicly outside of a non-disclosure agreement. And so if you have an upcoming disclosure in, say, January, I wouldn't suggest relying on Elevate IP grant for that if you haven't done a search. It's just that it's recently launched, and so they are still trying to figure out the kinks of the program, and there's no guarantee exactly when you would be approved. So depending on the situation, we can best guide you on how to approach these grants. It might be that you pay for the search yourself first, and then show Elevate IP that you have done the search, you're good to go, and then they will approve the filing later on. And so biggest difference is the amount that's available, as well as the fact that they cover for filings. So I'll go through at the end of this how we propose engaging with these programs depending on how your state of IP is, and then we'll talk about why one would apply over the other and how you can engage more fully. But again, like if you haven't done IP Assist, then we can use part of the funding available under Elevate IP to develop a strategy. So that could include some searching, gap analysis on your existing IP or the IP available as prior art against you that you're aware of through the searching, as well as leading towards the tier 3 work related to the drafting and the filing. And it's not even just Canadian filings. You can file in the US, any like a PCT application or beyond that. So they cover for any of those costs. I'm just going to pause right now. Are there any questions? Online questions? Okay.
Just again, pardon my ignorance. The first step is I would say a patent search. That's the first step. How would you start? You have an idea that you think is patentable, or you want to get, I would say, at least an idea of whether or not you're infringing somebody else's. So is the first step a patent search?
It depends. Patentability searches are not required to get funding under these programs for the application. It is required, but it depends on the business. Some businesses decide not to do any searching, and the reason why is that in the US, if you file in the US, the applicant as well as the agent has an obligation to disclose anything related to the patentability of those cases. So once you do a searching, you have to disclose those. It's not the end of the world. It does help. Typically does a patentability search, understanding the domain will help you understand how strong a patent application is. A patentability search doesn't give you an infringement impression. So patentability, anything before your filing date could be prior art against you. So it could be a barrier. Any portion of that application or any portion of what public disclosure could be a barrier to you obtaining a patent. Infringement, whether you infringe an existing patent out there in the world, depends on whether you fall within the claim scope. And so claims are really these unique sentences, typically at the end of a patent, are a combination of legalese and technical language that define the scope of that person's that patentee's monopoly. And so that's really a different type of analysis. And so a patentability search wouldn't even give you that sense. A patentability search may find a prior art document that's really relevant, and then maybe we'll have to engage in that infringement opinion. So going back to your question, like patentability search, it's not required typically to start the patent process. It's recommended just because it gives you a better sense of what may become a risk to you obtaining strong patentability down the road. It's a way of mimicking the patent examiner may do. Some of the limitations of patentability searches is that when you file for a patent application, it's actually not published for 18 months. So if I were to do a patentability search for you today, I won't be able to locate anything filed in the last 18 months. So 5 to 6 years ago for AI technology, when it became like a boom of technologies and various different types of applications, I wouldn't really recommend clients to do an in-depth patentability search at that point, because likely the competing application was filed within that window, right? So I would say in that case, for emerging technologies, file immediately, at least get something on file, have as early a filing date as possible, and then we can potentially do more searching and see what comes up in the next while. And then potentially we can improve on that patent application.
Thank you.
That's a great question. Right. So going on to the other big government program is IP Ontario. So IP Ontario is only available to companies incorporated in Ontario. Equivalents of that are going to be available over time. BC is developing one, so if you have an office in BC, something to think about as well too. And so IP Ontario is available to companies with 500 or fewer. So you'll see that's the big number, 500 or fewer. And so IP Ontario recently launched in the past year as well too. So they're again developing a lot of different types of programs. They're trying to work with companies and understand the ecosystem a lot. And so in the recent weeks, they launched different stream of fundings. So if you're under Altitude Accelerator as a client, you can engage with PESI or PAM and see how they can refer you through this program. And if you qualify under that stream, you can then immediately get access to up to $35,000 initially in funding and up to $100,000 again in lifetime for your company. Unique to IPON, IP Ontario, is that it covers, similar to Elevate IP, it covers the government filing fees and the drafting fees, but companies have to pay 20% of that. So IPON will only cover 80% of that. They also don't cover taxes. And it's not a huge deal, but it's just something to keep in mind that administratively, you have to pay that first before they reimburse you for the rest of it. So some clients have expressed that it's more annoying compared to Elevate IP and the type of IP assist program I've talked about. But it is really exciting in that it does cover drafting and filing of your IP. Another limitations of IP Ontario right now is that it is limited to prioritized sectors. And so medical technologies, life sciences, AI, automotive, mining, advanced manufacturing, if you're arguing within that scope, and they have more details on their website as to what that entails, then you would qualify for IP Ontario. This likely will keep changing. They recently added life sciences and mining. And so definitely keep a lookout. Even if you don't qualify for right now, you might eventually qualify for it. They are open for applications. So I would say definitely put your application in immediately. One of the differences with IP Ontario as well as Elevate IP is that it is a more administrative burden to go through this process. IP Ontario does require initially for you to obtain different service providers quotes and to work with IPON, IP Ontario to figure that out, to decide between these different service providers. I would say coming from a law firm and knowing other law firms, I would say don't just look for the lowest cost, and you look into detail as to what's listed in those services. A patentability search, for example, when I work with clients on it, I probably do, our firm is probably at the higher end of a lot of costs, but it's because we build into it our understanding of having to work with clients on understanding the technology. And I emphasize very early on, it's important to make sure you work with patent professionals who have the right language, right? And so it's really important to work with the clients to understand what could be the technology and figure that out in detail. And most of the time for searching, you might have an initial really broad idea coming in, and we find search results that knock out that broad idea, but it doesn't mean it's the end. And so we come back to you and say, hey, like this broad concept is probably not a good idea to pursue just as is, but let's think of the different ways you distinguish yourself from your competitors. You might have a very different way of approaching this problem and you want to implement it. And this is your distinguishing point from your competitors. So we focus and hone in on that. So for us working on a patentability search, it's not just the initial search. We work with you to figure out what's the strongest approach for developing a patent portfolio. And so something to think about definitely when approaching IP Ontario. We're listed service providers in all these programs, and you are free to work with Bereskin Parr and through Communitech. You just have to select us, and then I'm the point person for Communitech, so I will probably get the email. And if you're engaged with another professional, just let us know, and then we'll direct you to the professional within our firm. IPON as well, we're listed service providers, so you have to just select our names, and we'll be happy to work with you on a statement of work. We work with all these programs quite in depth, and so we understand how best to approach. And through that workshop, at the end of this presentation, we'll talk about how best to maximize these programs. But I think it's definitely important to work with professionals who have a good sense of what these programs cover to make sure that it's maximized in terms of how it can benefit your company. I'm going to go through a couple of different, not as well-known programs, and just something to keep in mind. Can export is actually currently on hold. It's been on pause since June. But what's really interesting about this program, and it's never been available before, is that if you're looking at partnering with a foreign partner and you want to protect yourself through IP in that jurisdiction, it'll cover 75% of that cost. So you do need to be a bit more advanced. So you have to have a prototype, depending on the technology space. It will vary what that means, but you do need to show a commercial plan within the next 5 years to launch. Again, it's not currently available. It's something to keep in mind, especially if down your pipeline you're thinking of engaging in foreign jurisdictions. Patent filings and trademark filings are jurisdictional. So if you want protection in Europe, each of the different countries, you have to file in those countries. There are ways to kind of reduce the amount of costs initially and delay decisions, and we'll work with you to develop a filing strategy. But this is something interesting if you have foreign partnership in mind later on. This one I learned about through a client of mine. I think it's actually pretty cool. The federal government launches these challenges once in a while. Last I looked, last week, there wasn't any available, but something to keep in mind. They launched, for my client, they were in the drug testing space. And so they launched a drug testing challenge and they won 3rd place. And they didn't get the 1 million, but they did get a good hefty amount of money. And so they do different streams of challenges and they call for proposals. So the challenge stream is a little bit more early stage. The second one is more prototype testing. And so something to keep a thought on and just look at it. I think they had some more clean tech space ones recently. And so I think it's really cool that we're trying to drive innovation, at least the federal government is. And the final piece here is the BDC IP-backed financing. This is for a bit more advanced companies with an existing portfolio. And so you do need to have some revenue in ahead before you can pursue this path. But this is something to keep in mind down the road. I mean, we're all trying to commercialize and succeed with our companies, right? So this is a different way of approaching IP and just thinking about IP as well, too, because IP should not just be a cost for you and your company. It should be a way for you to be able to commercialize. It should be an asset that you can get money for in one way or another. And so this recent launch in the pre-ish pandemic timeline. The people running this program used to be with Quantius. They were also a private lender, and now they have a very sophisticated approach and they understand IP. And so it's a pretty interesting program that they have developed. So we're going to enter the workshop portion of the presentation. Are there any other questions right now? Online questions? No. Okay, so again, Bereskin Parr is here to assist. We are service providers in all these. We have engaged with all these different programs. As I emphasized before, these programs can complement each other, but they cannot be used to pay for the same task. So, for example, a patentability search for one subject matter. You may do this at the end of your IP assist funding. And so you might only have $2,000 left on the IP assist funding, but the cost may be $4,000, $5,000. You can't use part of $2,000 from IP assist and part of $3,000 from Elevate IP to cover that same search. And so that's something to budget ahead of time to think about what can we fit within this $18,000 under IP assist, and then what can we put under Elevate IP to then work towards that next step, or how to complement that. And we can assist with the statement of work to develop the cost estimates as well too. IP assist, depending on which route you go towards, there might be different types of application. It could vary with ITAs as well too. And then so we can help as far as we can from the cost and IP perspective, but sometimes they require a bit more from the company perspective. So we'll assist as much as we can. So again, for people online, if they want a soft copy of this, feel free to email me afterwards. I'm happy to share that. But this is just what we have prepared to help guide you through this process. And so just personal information, but think about from the company and from company side, how many employees you have. If you're above 500, then you can't qualify for any of these programs. We're happy to assist otherwise, but these programs would not be available to you. And so province of headquarters, that's something to think about. If you are in Ontario, then you could qualify for IPON, depending on tech sector. And then if you have an office somewhere else in another province, to keep that in mind, because the Elevate IP program is being administered across Canada by different administrative bodies. And so the requirements are a little different for each one. Whether one is easier to get will vary as well too. Our experience so far with Springboard has been much easier, the easiest process so far, because they were on a mission to give away all the money ASAP this year. And so the other government programs are Elevate IP being administered by the other bodies are a little slightly different. And so let's keep that in mind. Tech sector, if you're in none of the listed prioritized sectors for IPON, then you wouldn't qualify for IPON right now. But keep that in mind for future. They are adding technology sectors. And this is something to keep in mind now, to think about what programs which of them may apply to you and how best to maximize it. And so the first question we typically ask our client is, have you filed for any IP? So if your question is no, then we would suggest something like this plan, where our sample plan A of developing an IP strategy. So you haven't filed anything, you're trying to develop an idea of what your IP could be, your IP portfolio. So we would suggest starting with IP assist under the EPIC route. And that would lead to a level 1 presentation where we engage and talk about generally awareness of what IP is, what it could be for your company. And that's about a 2-hour presentation to you. And then you would qualify for IP assist level 2. And then over here is the EPIC route. So that's the keyword if you're engaging with an ITA to mention that. And so under this direction where you haven't filed for any IP really, some of the example services that you would consider is potentially an IP mining session. I found that to be very helpful for earlier stage companies where, you have a lot on the go. You haven't really sat down and document everything. You have a potential of different types of partners down the road, and you have potential ideas of how you want to grow your technology. So a patent life is 20 years, right? So we definitely want to think about the patent as you file it for at least the next 5-10 years of your company, and to make sure that we file a patent application that covers for that term. So with the mining session, what we found to be very helpful is that through about a 2-hour conversation, we talk with you about what you're doing right now. What are you planning on doing, and what's appealing to your investors right now? What's appealing to your customers? What are you attracting a lot of just interest within the sector you're in, and how can we protect that, right? It might be that you have to retain things as trade secret. It's certain things are not patentable. So recipes, for example, we wouldn't be able to patent. Data, for example, you can't patent. If you're more of an AI business where you're driving a lot of, you're obtaining a lot of data, and your access to data is one of the biggest uniqueness that you bring to the space, then trade secret protection for that data. And the fact that you should own that data, that's another consideration. And then we should discuss the agreements, the legal agreements surrounding the data ownership. Who do you really own it? Anyone who engages with the data, like, have they assigned overall rights to the company? Any employees or contractors you're bringing in, any third partner you're partying with, like, who owns the IP? So we should have that conversation, and IP Assist could cover that, as well as searches within patents. And then through the mining session, we'll talk about those priorities. And then at the end of it, we typically develop an IP documentation. We call it invention summary if it's more patent side. And then from there, that document will really help you guide the next path towards potential investors. Say, hey, like, we have this mining session, we have this IP, we need money to cover this. We need money to pay for this down the road. And it also helps us understand the priority within it, because we'll group it based on invention that we would draft for patent. And so you might come out of the mining session with 3 main priorities, 3 main invention concepts. And then from there, if we budgeted for 1 or 2 searches, then you can choose which one you want to pursue under IP Assist, for example. And typically around that point, with some potential legal agreement review, it would be about the scope of the $18,000 under IP Assist Level 2. At the same time, I would suggest apply for Elevate IP and IPON as well too. And depending on timing, most of the time, once we finish the patentability searching here, you probably would hear back from one of these other programs, and then you can see where you fit in. Most of the time, if you've already done a search under IP Assist Level 2, they will ask, one of these programs will ask about it. And if the search results are positive, we have arrived at something that you can pursue a patent application with on a very strong basis, at least. Then they would give you the Tier 3 funding. The Elevate IP would give you the Tier 3 funding to cover for the drafting or filing of those agreements. And so that's a typical path. I would start with IP Assist Level 1, and then you get to Level 2, and with not much administrative burden. It is possible for you to kind of ignore IP Assist and jump straight to Elevate IP or IPON and go with that. But I found that it does cause a bit of delay, especially if you have a disclosure date coming up. If you are eager to work towards filing sooner rather than later, then this having the IP Assist complement one of the Elevate IP IPON programs has been really good. And again, under Elevate IP, the 2 tiers are maxed out a certain amount. If you don't use up the full Tier 2 money, the remaining portion can go towards your Tier 3, assuming you qualify for Tier 3. But Tier 2 is covered 100% by Community Tech, but Tier 3 will be covered a portion of it, depending on what the copay rate is at that point. And then similar for IPON, we've gone through it. It will depend on which stream you fit into. And so that's something to consider. So going back to our questionnaire here, if you have not filed for IP, we consider doing a version of the sample plan A, and we'll work with you to figure out what that means. And each situation will vary, and you might have different needs that we need to incorporate. And so we'll work with you on that budget. And if you have filed, what kind of filing? And then if it is a provisional application, then we can talk about whether you can qualify for the conversion of a regular. So if you have filed for some kind of IP, we consider the sample plan B, where you're growing an IP portfolio. So if you have filed for something, the priority may be to convert the provisional into a regular application. So you would need to focus on Elevate IP or IPON, one of them. In order to get funding, again, for Elevate IP or IPON for filing applications, you do need to have done a search. And so it depends on if you've done a firm or a searching agency to help with the search, then you can talk with the IP strategist, the IP, I think they call it the IP professional, or I can't remember what they call it, but the person who decide whether you qualify for tier 2 or tier 3, and you can talk them through their search results, and then they can decide whether you qualify for tier 3 funding. So if you have IP already filed, under IP Assist level 2 and 3, you can still qualify for it. But we would suggest something different. So again, under the IPIP route, where you just pay them $500 min fee, you can get $18,000. But the NRC route, so the other type of IP Assist where you have to do a proposal, what's appealing at this point where you're a bit more advanced in your IP development is that potentially you want to go down the NRC route where part of your internal salary for whoever is running the IP program can be covered under NRC. So that's it was appealing for some of the clients to do that because it does take some time internally to work with us to figure out exactly your IP portfolio. I would still suggest IP mining sessions too for a more advanced company, because even if you have IP filed, you likely have done other things in the meantime to develop. We can work with you to document it, to figure out exactly how your current filings cover it or not. And so it's part of that gap analysis that we can work through. And again, development of commercialization plan, review legal agreements, and we can work with that. But the emphasis for growing an IP portfolio would be probably focusing in the Elevate IP funding, the full $100,000 to potentially most of the tier 3 drafting, filing, international filing, growing your potentially US portfolio through continuations, and then or prosecuting applications as well too. And then another route is IP Ontario through, depending on which stream you qualify. So going back to our questionnaire here, so if you have some filings, consider the sample plan B. And then another thought to keep in mind when going through these government funding programs is whether your agreements, some of the examples listed here, have been reviewed by an IP lawyer. So when we look at the IP clauses, we do think of it from a very different perspective than most other lawyers who don't specialize in IP. And so we would say at least have an IP lawyer review the IP clauses and not the full agreement, depending on what it is. And have you consider how you plan to commercialize your IP, because we can then focus in on the agreements you might need in place, how you want to utilize and commercialize your IP. So we can help and assist with that as well. So that's the end of the presentation. Do you have any questions?
You want me, do you just stop presenting?
Sure.
You can see on the people online.
Hey, Hessie, there are no questions online, but I would request audience, if they have any questions or queries, please raise your hand or unmute yourself and feel free to ask those questions to Joanna.
Touchy screen.
Do you see?
Okay.
Okay, that's okay. We can see you. You can't really see us.
Sure.
So no questions? Well, we'll have the presentation recorded. So we'll send out a copy of the video to everyone by email. And also Joanna's email will be part of that email. Should you have any questions, you can send it out to her directly. Okay.
And everyone online, Joanna will also make available the digital copy of the presentation, should you want to have a copy of that as well. All right?
Great, thank you.
Thank you. Thank you. Everyone.
Much.
Hey, Ratusha, I'm going to sign off. Thank you everyone online for joining today.
Yeah, I'm just going to stop recording.
Thank you.